Well, good afternoon, everybody. Thanks so much for joining us. We are going to get things kicked off here. Thanks for joining us for today's webinar. For those of you that were able to join us yesterday, hopefully throughout the week, we're able to connect with you one-on-one through our virtual office hours. But today we're excited to talk a little bit about some of the employment laws and changes due to the COVID-19 crisis. And we're fortunate to have a guest speaker here with us today to walk us through some of the changes, as well as how your individual business can go about navigating some of these requirements due to the COVID-19 situation. Just a couple quick announcements for today and the rest of the week while we're letting some other attendees join. If you're having any difficulties with the audio or hearing us, feel free to call in via your phone. Sometimes this can give a better connection instead of Wi-Fi. Due to the number of attendees we'll have joining us today, we'll be unlikely to be able to troubleshoot any technical issues, but we are recording all of these webinars and past webinars. We'll be posting them on our Vimeo account as well as on our website. So feel free to call in if that's easier on your end. And it's just a quick reminder, the Generator and Brandery team, we're hosting office hours to connect one-on-one with everyone throughout the week. We have slots available from 9 a.m. to 5:30 p.m. every single day. Additionally, Sarah, who we'll introduce here shortly from Taft, will be hosting office hours immediately following the webinar from 1 p.m. to 2 p.m. For an optional kind of one-on-one deeper dive with you and your business. And then in addition to that, we also have HCDC hosting office hours with us this afternoon from 1 p.m. to 4 p.m. All of that information, as well as the sign-up links, are in the email that I sent out last night, as well as the original schedule that we sent out on Sunday night. So feel free and please do take us up on those offers. We'd really like to dive a little bit deeper with you individually and see what kind of custom creative solutions we can come up for you and your business. And then during today's webinar, we will be taking live Q&A, and Sarah will be trying to answer all the questions that you may have about your individual case or business. We'll reserve the last 20 minutes or so after the webinar. There's a Q&A box that you can access via Zoom, and you can type in your questions and send to the host. And if we're not able to get to any of your questions, we'll make sure to send them to Sarah after the webinar and get back to you. Please just make sure that you don't put those in anonymously so that we can make sure we're getting the answer back to the correct person. And if for some reason you're having trouble sending them through the Q&A box, feel free to send me an email at jeff@brandery.org. or Jess, who's also on during the webinar as well. And with that, we're honored to have Sarah Clay Leyshock, partner at Taft Law, with us today. Taft's been a long-time sponsor for us. Sarah focuses heavily on employment law and has been navigating kind of everything with her clients and beyond for this COVID-19 crisis. So Taft's put together some great resources, and Sarah's going to walk us through just some of the changes due to this kind of ever-changing landscape, and some things that you should be thinking about, considering, precautions to take, as well as things that you can be doing to get ahead of the curve. So with that said, I'm going to pass it over to Sarah and let her share her screen. And thanks again, Sarah, for joining us. It looks like you may be on mute on your end, Sarah. Awesome, we got your screen.
All right, I think I'm all set.
Yeah,
thanks everybody for your patience. Jeff, thank you for the introduction, and everyone, I appreciate you calling in, taking the time to learn about these new laws that have been enacted recently in light of the coronavirus pandemic. And certainly I have a list of some existing laws that I want to put on your radar as well, because there's a lot of business transition, business strategy considerations that are that businesses have been forced to think about due to the current circumstances for at least the past several months, and will continue to need to think about these issues and ideas, legal considerations, personnel management as we go. And as we go, we don't know how long that's gonna be right now, but at a minimum, most of these laws apply through the end of this year. So I think for the most part, most of us are thinking about now until at a minimum December 31, 2020. So again, we'll talk about new laws. We're going to talk about just a real quick overview of the CARES Act, which is the stimulus bill, and the Families First Coronavirus Response Act, which I call the FFCRA, and that's the law that provides paid sick leave and partially paid FMLA that is impacting employers. It took effect on April 1. Those are the new laws that I think most people have many questions, many good questions right now. We've been getting guidance from the Department of Labor on a rolling basis, and so it's really interesting. If you attended a webinar last week or the week before, the information you may get today may be slightly different from what you heard then, and it's just really important to realize that we are trying to get to the bottom of every bit of information we can get from the Department of Labor, and for better or for worse, some of it is contradictory or inconsistent or just unclear, and so we're trying our best to make do with what we can and provide the most recent, up-to-date advice and information, and also just let people know when there's been substantial changes. So those are the two new laws that we'll focus on in our 40-minute talk, and then I want to save about 20 minutes at the end for questions. So the existing laws and topics that I have listed here, I will just briefly at the end walk you through those on why you should be thinking about it, depending on where you are in a personnel management decision-making process or your long-term business strategy review. You may or may not have a lot of questions on some or all of these topics. So it's important to just keep your mind open to not only what's going on, what's new, what do I need to learn about in order to take advantage of very current updates, but also keep in mind there's very important existing laws that we need to continue to comply with. So the first item I wanted to talk about was the CARES Act, particularly because of the type of law that it is. It's a stimulus bill. It provides support and various loan programs, financial assistance to not just individuals, but also to businesses. So there are a variety of different programs available to support businesses in the CARES Act. I'm going to talk to you today about the payroll protection loan because I think that's probably most applicable to smaller businesses. There are other options out there. Also, we'll talk a little bit about the expanded unemployment compensation that this CARES Act is providing. So the payroll protection loan is available to small businesses who have 500 FTEs or full-time equivalents and less. That includes nonprofits, veteran organizations, self-employed individuals, and sole proprietors and independent contractors. So not exactly what we would typically think of as an employer, but rather a small business with less than 500 FTEs. What it provides is 2.5 times the average monthly payroll during your past 12 months, up to a maximum of $10 million. That is a government-backed loan that is potentially entirely forgivable. It must be used only for certain qualified expenses like payroll support, employees' salaries, rent, utilities, interest payments on mortgages, not the principal payment, and any debt that existed as of February 15th. So this is essentially a loan that is forgivable depending on whether you make any adverse employment actions, layoffs, or salary reductions within the 8-week period following the loan disbursement. So as I said, there's great terms. There's a reason that this is being provided in the state of emergency. It provides a significant amount of cash to employees or businesses who may be struggling because of the coronavirus pandemic. The terms of the loans are very favorable. There's no personal guarantee required, no credit elsewhere test, no collateral must be put up. The interest rates are capped at 4%, but again, that's only for the portions of the loan that are not forgiven. So the loan can be forgiven as long as it's used for payroll costs, mortgage interest, rent, and utilities. And then to the extent that the employer does engage in layoffs between February 15th, or I'm sorry, since February 15th, the loan forgiveness will be reduced on a pro rata basis unless the employer is able to rehire that employee or return the employee to their previous level of wages by June 30, 2020. So this isn't one of those situations where if you didn't know and you took adverse action in anticipation of struggling business circumstances because of the coronavirus, that you're now disqualified. There actually is some wiggle room here where if you're able to re-engage, rehire that employee at the same level of pay they were at before, by June 30th, you can still have an entirely forgivable loan under this PPP. And then another great term is that these loans are not taxable income to the borrower when they are forgiven. So the only caveat here is the applications for these loans the application process opened up last Friday, and the loan funds are being provided on a first come, first served basis. So if you haven't got your application in, you'll want to do that right away. The CARES Act also provides some other important business support and individual support. There's loans for medium to large businesses. I didn't get into the details in our materials here. There is an opportunity for deferral of payroll taxes. There's a refundable unemployment tax credit if you don't participate in any of the SBA loans. And then, of course, we've all heard about the expansion of the unemployment compensation program. So there is now, for the first time, a temporary pandemic unemployment assistance, which is a form of unemployment for self-employed individuals, those who work in the gig economy who are able to self-certify that they're unable to work because of the coronavirus. So now we have unemployment assistance, so to speak, for these individuals. We've never had that before. There's also an additional $600 per week unemployment compensation that will be provided for a period of up to 4 months. There's extended state unemployment benefits that will last 13 longer in most states. That takes most states' unemployment duration to 39 weeks of compensation. The government is also trying to encourage employers to participate in work share programs that avoid layoffs. So in essence, instead of laying off 2 employees out of 10, you might reduce the schedule on an equal basis of all 10. And then as a result of the schedule or hours reduction, which is of course going to equal a pay reduction, these individuals will be entitled to receive unemployment benefits through, in Ohio, it's called the Shared Work Program. So you'll apply. It's a program-based compensation offering, and so the employer applies on behalf of a company or a program, and the CARES Act provides some benefits to encourage employers to participate in that in order to avoid layoffs. And then there's also some provisions of the CARES Act that help soften the blow for individuals who are impacted prior to the implementation of the CARES Act, so starting back in January 2020. So the next big piece of new legislation that we've seen is the Families First Coronavirus Response Act. So I call that the FFCRA because I've said it probably a million times over the past few weeks. And this is a piece of legislation that was enacted very quickly. And as a result of the quick enactment, there have been some inconsistencies discovered in the various guidance released by the Department of Labor. There's some lack of clarity on a few issues. Every day, maybe not every day, maybe every other day, we're getting additional guidance from the Department of Labor that is intended to help clarify some of those issues. It doesn't always do that, but we're working on trying to streamline sort of the very basic rules of the program, and ultimately the purpose of this FFCRA is to provide paid leave so that employees can attend to personal health and family matters that will definitely arise as a result of the coronavirus pandemic. So I have a link in your materials here to the Department of Labor's website, where they are pushing out guidance, as I said, on a fairly daily, if not weekly basis. So I want you to familiarize yourself with this link. It's very helpful. Not only is the law, can you connect to the actual act and regulations here, but you can get to a list of, I think we're up to maybe 38, 35 questions and answers that are intended to be really clear for employers to help understand their obligations and how to administer the FFCRA. So please feel free to use that as a great resource. The FFCRA essentially has two components. One is an emergency paid sick leave component. The other is an emergency or an expanded Family Medical Leave Act component. And quite frankly, the third really important component is the tax credit that is available to employers who provide these paid leave wages to their employees, right? So that's what makes it affordable. So we'll talk about each of those. One thing you need to keep in mind is the emergency paid sick leave allows employees to take leave only for these 6 specific reasons, no other reason other than these. If you provide leave to an employee that is not covered by one of these reasons, you are not eligible for the refundable tax credit that's available. So keep that in mind. So the 6 reasons are because the employee is subject to a government mandated quarantine or isolation order, because the employee has been advised by a healthcare provider to self-quarantine, because the employee is experiencing symptoms of the coronavirus and seeking medical diagnosis, because the employee is caring for someone else who's subject to a quarantine order or a healthcare provider's advice to self-quarantine, because the employee is caring for their son or daughter whose school is closed or their child care provider is unavailable because of the coronavirus precautions. And then this last one, unfortunately, remains unclear. It is what it says. Leave is available if the employee is experiencing any other substantially similar conditions as specified by the Secretary of Health and Human Services. And to date, that has not been specified. So it's kind of a placeholder. So one of the questions we get very, very frequently is, what do I do if my employee has a fear of contracting the coronavirus and they don't want to come to work? Some employers say their employees' fears are reasonable. Some employers report them as being oversensitive and not reasonable. But what I want to point out here is that, unfortunately or fortunately, however you look at it, the fear of contracting coronavirus is not one of the reasons here for taking emergency paid sick leave. So if an employee says, I can't come to work because I'm afraid I'm going to contract the coronavirus, they're not covered by the EPSL. They're not entitled to be paid under this law, and you can't take a credit if you do choose to pay them for providing that leave. What I do want to point out is in the temporary regulations that were just issued by the Department of Labor on April 1st, the department did make clear that if a doctor orders someone to self-quarantine, because that individual is particularly vulnerable to the coronavirus, that is covered by reason number 2. So I would consider that a reasonable fear. It's not based on the fear, it's based on the doctor's order, to which you are entitled to obtain documentation from the employee about that order. But just be clear, when employees come to you and say they have a fear, they really might be eligible for leave if they handle the situation appropriately, but it needs to fall under number 2. It can't just be, I decide for myself that I'm particularly vulnerable. We need a doctor to say so. And that usually covers individuals who might be elderly or who have underlying health conditions. And it's important that we handle those, we treat those individuals the same as we treat all other employees, because we don't want to make any decisions about their ability to work or about whether we continue to allow them to work based on their age or an actual or perceived disability. So what we want to make sure here is, if we have a situation like this, let's analyze it in terms of, have they met the requirements for EPSL, reason number 2. The other question that remained unanswered for a long time, but luckily has been answered by the Department of Labor more recently, is, are the government mandated quarantine, isolation orders, shelter in place, stay-at-home orders, is that what is meant by reason number one? If an employee is unable to work because their business is considered non-essential, are they eligible to take leave under number one? It's kind of a complicated issue. The answer is, does the employer have work for them? So if they are an essential business and the employer is still operating, but because of some language in an order that says individuals who meet certain age or health conditions or perform non-essential jobs for an essential business, if that order requires them to stay home, and but for that order, the employee would be able to work, then yes, they would be entitled to leave under reason number one. However, if they are not working for some reason other than one of these reasons, they do not qualify for EPSL just because they also happen to be subject to an order. It has to be but for this particular reason. So what is EPSL? Well, EPSL is 2 weeks of paid time off, but it's not for any reason. It's only for the 6 reasons articulated previously. And it's 2 weeks or 80 hours of paid leave for those who are considered full-time. You may have defined full-time differently for purposes of your policy or your practices within your organization, but under the FFCRA, full-time means an employee who's scheduled to work 40 hours a week. Anyone who's scheduled to work less than 40 hours a week is considered part-time, and in that case, their paid sick leave benefits are equal to 2 weeks based on the number of hours they normally would have worked in a 2-week period. So as normally scheduled. And then it's also important to remember that EPSL is not necessarily full pay. It depends on the reason the employee is taking leave. If they're taking leave for the first 3 reasons, because of a government-mandated quarantine order, because a healthcare providers advise them to self-quarantine, or because they have symptoms and are seeking medical diagnosis related to coronavirus, they do get 100% pay, up to a maximum. That's a daily maximum and a total leave maximum. If they take leave for any of the 3 bottom reasons, so 4, 5, and 6, they're caring for someone else, they're caring for their child whose school is closed, or this random 6th category, they get 2/3 of their pay, up to $200 a day, or that's $2,000 over the duration of the leave. So it's important when you're administering this policy that you track the reason the employee is taking the leave, and you make sure that you compensate them according to these maximums. Any amounts that you pay them above these maximums are not eligible for the tax credit. So the other portion of leave that's available under the FFCRA is an expanded FMLA leave. So FMLA is typically unpaid. It's never been paid before, but now we have this new EFMLA that provides a 2/3 pay benefit for a period of up to 12 weeks of leave that can be taken for only one reason, and it's reason number 5 under the EPSL. It's because the employee needs to be at home and cannot work or telework due to their children being home and the need to care for them. It also requires the employee to certify that no other suitable person is available to care for the child. So as I said, this is up to 12 weeks of pay at 2/3, but remember, the first 2 weeks under the EFMLA are unpaid. So there's no pay due for the first 2 weeks that the employee takes leave to care for their child. On the other hand, they do get 2 weeks of paid leave at 2/3 their pay under EPSL. So ultimately, if I get rid of all these confusing labels and alphabet soup, under the EPSL and FMLA combined, they're entitled to up to 12 weeks of pay at 2/3 their rate if they need to be home because their children's school is closed or care providers unavailable. Some things to keep in mind in terms of the FMLA and EFMLA. The employee gets up to 12 weeks, but we need to take into consideration any FMLA that the employee used within the past 12 months, so within the typical FMLA year. So the employee doesn't get a full 12 weeks of EFMLA if they've used within the past 12 months, say 2, 4, 5, 6 weeks of regular FMLA. It's a total combined number. And the employee, under the EFMLA, the employee must have worked for the employer for at least 30 days prior to taking leave. And under the PSL, there is no duration requirement. So all employees are covered regardless of how long they've worked for the employer. Just like the regular FMLA, EFMLA provides job protection, and employers are required to use reasonable efforts to restore an employee to their equivalent job after the leave, unless they can demonstrate that the job would have been eliminated regardless of the fact that the employee took leave. So who's covered by FFCRA's EFMLA and EPSL provisions? It is almost all employers, as long as they have less than 500 employees. And unlike the CARES Act loan measurement, this does not take into account FTE. So we are just talking 500 bodies, no matter whether they're full-time, part-time. It also takes into account any employees that might be jointly employed between you and another organization, or if you might be considered an integrated employer under the regular FMLA, then both integrated employees must be counted for purposes of determining if you have less than 500 employees. So we do have two exemptions to the FFCRA leave provisions, and one is for healthcare workers and emergency responders. And more applicable, I think, to all of us today is the exemption for small employers with less than 50 employees. If you can demonstrate that providing the leave would jeopardize the viability of your company. So you're saying, how in the world, Sarah, do I do that? Well, the regulations that were issued last week told us that you should provide maintain documentation of one of these following categories. And if you can do that, then you can defend yourself should the Department of Labor or a lawsuit be, should the Department of Labor investigate or inquire, or if there's a lawsuit challenging your decision to deny an employee leave. If you're a small employer and you can demonstrate that causing leave would create your financial obligations to exceed your revenue, and therefore you'd be impaired in your ability to operate even at a minimal capacity. If you can show that the absence of the employee would pose a substantial risk to the financial health or operations of the business because of the employee's particular skills, knowledge, or responsibilities within the company. Or last, if you can demonstrate there's just not enough workers who are able, willing, and qualified to do the work that needs to be done at the time that it needs to be done, then you may be able to justify denying an employee leave. So as I mentioned, the Department of Labor will enforce these laws, and employees can file a private lawsuit against an employer for violating their rights under the FFCRA. The penalties for violations are similar to those under the FMLA, which includes lost wages and benefits, out-of-pocket costs, liquidated damages, attorney's fees, and potentially a reinstatement if an employee is terminated. And then the same as the FLSA, which is a little problematic because that includes lost wages and benefits, liquidated damages in an equal amount of the lost wages and benefits, attorney's fees, and fines and criminal penalties, and the opportunity to bring a action on behalf of all similarly situated individuals. So it's sort of like a one-off from a class action. So very importantly, in order to be able to afford providing this leave, the law does provide a 100% tax credit reimbursement for all leave that is paid as EFMLA and EPSL. So the amount that you're required to pay the employee actually matches the amount of the credit that you can receive. and the credit is applied to the employer's portion of the Social Security tax. And in order to try to make that cash immediately available, the Department of Labor has said that employers may immediately use payroll taxes that are being withheld from all of their employees' paychecks to turn around and pay employees wages during their FFCRA qualified leave. And then if that's insufficient, there's actually a process for employers to request an accelerated payment from the IRS in order to provide this paid leave. So one of the more advanced questions that we get is, what type of notice can I require from my employees? And I'll just say generally reasonable, but I'll also say that the Department of Labor is expecting employers to be fairly considerate of the chaotic and fluid circumstances that we stand in. So if the need for leave is foreseeable, employers should provide notice. Employees should provide notice of their need as soon as practicable. If it's not foreseeable, the Department of Labor says it would be reasonable to allow the employee to notify you the same day that they miss work or the next day thereafter. If they do call in, you need to ask them to provide enough information so you can determine if this is an FFCRA absence or something else, so that you can differentiate how to handle it under your standard policies or under this law. And then if the employee doesn't give enough notice, the Department of Labor says that employers should simply tell them that they didn't provide enough notice and then ask them for documentation to support their need for leave nonetheless. So I won't get into this detail. There is a detailed list of what documentation employers can ask for in order to have an employee support their need for leave. The Department of Labor does require that employers obtain this documentation from their employees and then keep it for at least 4 years. Another more advanced question is, do I have to let my employees use EPSL or EFMLA on an intermittent basis? The bottom line is it's only allowed if the employer wants to allow it. But even if you do allow it, the Department of Labor says in order to reduce the spread of the coronavirus, employees who are required to work at a work site cannot be allowed to use intermittent leave if they take leave because of coronavirus, actual health-related reasons. Those are reasons 1 through 4 on my list. All right, so I have some other questions here set out for you. What do I do if I've already provided leave to employees before the effective date of the FFCRA? Unfortunately, the law does not give employers credit for that, so you can't deduct from their leave allotment any leave that you provided to them before April 1, 2020, which is the effective date of the FFCRA. You have to be careful not to retaliate against any employee who takes any of these leaves. That being said, you do not have to be shy about making legitimate business decisions while an employee is on leave. If you can demonstrate that a layoff or other adverse employment action would have happened regardless of the fact that the employee was on leave, then it is a lawful decision. So just really quickly, I want to walk you through the list of other employment topics that you should be thinking about when you're looking at your personnel, what to do, what types of strategies to take. We have a lot of employers who have been instructed to utilize social distancing if they're going to continue to work, maybe take the temperatures of their employees. Keep in mind that under OSHA, employers have a general duty to provide a safe workplace that's free from recognized hazards. So in a nutshell, an employer has an obligation to stay up to date on the most current health-related information provided by the CDC, maybe their state health organizations, and then provide what I would call PPE, personal protective equipment, and all the all the recommended social distancing, hand washing, and other coronavirus-related protections, and ensure that it's happening vigorously in the workplace and managers are properly enforcing all of those standards. In general, the coronavirus is not likely to be a disability under the ADA, but because we are talking about individuals and their health, we need to be careful that we are not perceiving or regarding people as either disabled or potentially disabled when we are dealing with their health issues and making decisions. If you choose to take temperatures of your employees, keep in mind that that is considered a medical examination, so the information that's collected during that process must be maintained confidentially, and your employees who are interacting must be equipped with PPE. Also keep in mind as we change the way the workplace looks, we make decisions impacting our employees. All employees have rights under the National Labor Relations Act to discuss the terms and conditions of their employment in a collective manner. And so this does not apply to just unionized workforces, but in fact all workforces. So you want to be careful if you are implementing any rules that might be perceived as shutting down this type of collected concerted activity. If you have employees working from home, which most of us do, make sure you have a remote work policy in place that all employees are aware of, maybe have them sign it. And it should cover a whole variety of topics, not the least of which is employer expectations, and then equipment. Warn employees that they are responsible for any harm to third parties that occurs in their home while they're working from home. And then, of course, it's very important that they take all reasonable protection to maintain the confidential nature of the company's information and to protect trade secrets. So we have here just a list of the state-based stay-at-home orders. I'll be honest, I'm not sure this list has been updated in a couple days, so it may not be the most current. But I just want to point out that almost every state is dealing with some sort of restriction on its workforce, and every order is worded differently. And so it's important that if you have employees in multiple states, that you're looking at every single applicable order and making sure that you're complying with it. There can be penalties for non-compliance, and there could be procedures that are available to you that would allow you to continue to operate in a way that is beneficial to your business. You just need to make sure that you're fulfilling all of those requirements. Most of them sort of categorize businesses into two categories, essential and non-essential. Obviously, essential tends to be healthcare, government functions, grocery stores, and pharmacies. Some allow religious institutions or educational institutions to continue to operate on a remote basis. And then gas stations and transportation is typically considered essential. And we can certainly get into the more nitty-gritty of whether supply chain, businesses on various supply chains may be considered essential. But again, there's a variety of orders. There's federal orders, there's state orders, so you want to make sure you're complying with the ones that are applicable to you. One of the strategy decisions that a lot of employers are having to consider is whether to do any furloughs and layoffs. And these are not legal terms. A layoff is essentially someone who has lost their job because there's no work for them. A furlough is someone who has lost their job permanently or temporarily because there's no work for them. Typically, when we use furlough, there's an expectation or a possibility that the employee may be reinstated. Just be careful that you're treating these like terminations, and make sure that you are going through the same process that you would for any other termination, making sure the decisions don't appear discriminatory, making sure you're providing COBRA notice. You may have unemployment notice obligations in your state. And then in terms of accrued paid time off, do you have to pay that out to employees under your policy or state law? These are the types of things we typically look at a termination. And then also federal and state WARN acts. which apply when an employer has a plant closing or a mass layoff, as those terms are defined under the law. But essentially, employees are entitled to notice, and the state unemployment organization is entitled to notice if more than 50 employees are laid off within a 90-day period. So the reason this should be on your warning is because you might think, well, I'm only going to lay off 10, so this doesn't apply to me. But if a month down the road you lay off 40 more, or if 2 months down the road you lay off 40 more, you may be hitting that 50 number threshold. And certainly the analysis is a lot more detailed than what I've just provided. But keep in mind that we're looking at 90-day windows. That's looking forward and backwards in any 60-day period. There are exemptions when the layoff is unforeseeable. And certainly we think this coronavirus situation for many of us has put us in situations where we may not be aware of the layoffs we may have to take a month down the road. But the WARN Act does still require that employers provide as much notice as practicable under the circumstances, and then also that they document and explain that this was unforeseeable in the notice to employees. And failure to comply with the WARN Act does result in damages of back pay, benefits, and attorney's fees to any of the impacted employees who did not receive the legally required notice. And then I think, yep, this is our last topic here. I just wanted to say, keep in mind your wage and hour obligations. So for hourly employees, they must be paid for all work that they perform for the company when the business has reason to know that the work is being performed. So if you have hourly folks at home, you need to make very clear how much work they're allowed to do and make sure that they're reporting all time. It probably is a good idea if you have employees working remotely to remind them of their wage and hour obligations in terms of recording all time worked. If you have exempt employees, you need to make sure that you are paying a full week's salary during any week in which an employee performs any amount of work. So if you have a furloughed employee who is exempt and they decide to pick up and do an hour's worth of work now and then, they've worked in that week and they are entitled under the law to a week's worth of compensation. So it's really important that you take appropriate measures to make sure the employees know when and how they're allowed to work, how to report it. And then, you know, something you might consider doing if you have a laid off or a furloughed employee is disconnecting them from your email or network system just to ensure that they understand that they are completely furloughed at this time. They cannot perform any work because the company can't afford to pay. It's nothing personal. All right, so I will go ahead and see if we have any questions. Looks like we have about 15 minutes left.
Awesome. I'm going to kick off the Q&A. So Mike wants to know, how best do you recommend documenting that your organization is eligible for the exemption from the FFCRA leave provisions?
I think that is a great question. So there is no defined format, but I would say more is more. So first of all, if you wrote me an email and said, Sarah, I want to qualify for the exemption, here's why, and you told me everything, and then you say, what should I include in my documentation? I would say everything that you just told me and all documents supporting the statements that you just told me. And I would wrap it up either in a file or scan it to your network, and I would save that for a minimum of 4 years, but I would probably recommend 7.
Great, thank you. And then another question from Joe, is there any way to support an employee that wants to reduce to 50% to support kids at home? Can they receive a portion of salary and then use a portion of FMLA?
So if the employee is eligible for FMLA and wants to take it, is applying for it, you must provide that to them. Now, they will be receiving compensation under the FFCRA at a reduced rate at 2/3. They can use, this is within the employer's discretion, they can use available paid leave to supplement that. So in very basic terms, they can use a 3rd day of PTO to bring their pay up to full pay during the 10 weeks following the first 2 weeks of unpaid leave. So you can certainly allow them to use their paid leave to supplement that. You could also allow them to reserve their paid leave to use at the end of the 12 weeks of 2/3 pay under the EFMLA. So if they anticipate needing more than 12 weeks and they want to stretch out their pay, you could certainly do that. The other option is if you have an employee who, it gets complicated in terms of voluntary layoffs. I don't want to provide, I don't generally think that's a good idea. But if you have layoffs or reduction in hours that need to be made, and an employee in that circumstance fits the requirements for your selection process and is selected, they may be eligible for some unemployment as a result of the reduced hours.
Great. And then another question, can you require an employee to go home if they have a temperature per the governor's suggestion?
Great idea, yes. Be respectful, but yes.
That was a quick and easy answer. Okay, does anyone else have any more questions? Just make sure you are putting them in the chat portion of Zoom so I can read them out loud. So we'll give everyone a minute in case anyone has any more questions to type it in.
Awesome. Well, if anyone doesn't have any other questions, big thank you to Sarah for kind of walking us through everything. And I know we got a couple signups for the office hours directly following this. And just as a reminder, I put that link to sign up with Sarah directly in the chat here. And again, it was in my email last night as well as Sunday. So feel free to take advantage of that. Big thanks to Sarah for hosting those office hours and taking the time to walk us through this. If you do have any additional questions that you didn't get a chance to ask or put through the chat box, feel free to, again, follow up directly in office hours with Sarah or reach out to Jess or I via email, and we will make sure we get those answered for you. And thanks again, everyone. Thanks, Sarah.
Thanks, Jeff.